Hello and welcome to the podcast. I'm Karen Weaver. With the 2025 NCAA Convention fast approaching, I wanted to visit with an attorney who was in regular conversations with Division I campuses about navigating their futures. They ask my guests tough questions, and she provides legal clarity as best as is possible in this crazy upside down era. Kelleigh Irwin Fagan is a former college athlete, a golfer, I believe, and she co-founded the sports law practice at Church Church Hittle Antrim 10 years ago. How does a university leader manage the legal unknowns for D1 programs? What advice might she have to offer for trustees and presidents at this tenuous time? Let's find out. Kelleigh, welcome to the podcast.
Well, thank you so much for having me, Karen. I'm happy to be here. And it is great timing with the convention next week.
Absolutely. So let's start. What's the top of mind question that you're getting most asked?
Yeah, I think almost every day we're getting a question on the House settlement.
Okay.
That's dominating college athletics right now, outside of the actual competition and the football playoff going on and some of the more things the public is following, but from a legal standpoint and strategy and trying to think ahead and how are we going to deal with this, the House settlement is prominent in every Division I athletic department, and the questions we're getting are different, because there are so many differences amongst Division I institutions. So we really get a wide range of questions and issues that come up that we then try to help advise on and help people navigate. Yeah, a lot of uncertainty when you don't always have very clear information.
Those in buckets for me. Do you have like 2 or 3 or 4 buckets of questions that you're getting?
So I think maybe we can start with like the threshold question that we get for the non-defendant conference schools. So the schools that don't have to opt into the settlement is, do we opt in, and what are the considerations that go into that? And obviously we bring one piece of that and some of the legal considerations and our background and our team's background in college athletics, hopefully allows us to provide from experiences of my colleagues on campus and conference offices. But there's a lot more than just the legal part that schools have to think about when they're trying to decide if they're going to opt in or not. So that's one bucket, is sort of the question of opt in or not.
Let me just be clear with the listeners. What do you mean by those who aren't automatically? Define conferences, if you would.
Sure. So there's the Power Five. I realize that term is sometimes referred to as the Power Four now, but the defendant conferences to the House settlement include the Power Five conferences, and they're opted in. They have to opt into the settlement. They have to comply with all the reporting obligations, and they're subject to some of the restrictions regarding the amount of benefits that can be paid and roster limits. Conferences and then member institutions within those conferences that are not named defendants do not have to opt in, but they can't. If you're going to try to do a little bit of this new House settlement, then you're opted in. So it's an all or nothing. You're either in or you're not. And the NCAA came out with a Q&A, I believe it was last month, by March 1st of 2025, so not that far from now, that schools will need to determine if they're going to opt in or not for the upcoming academic year, assuming the settlement, gets final approval and does go into effect for 25-26.
Before you move on, let me ask you one other clarifying question. So if I'm a mid-major Division I school and we're debating and we decide we want to opt in a little bit, can we do that?
You can do that, but then you're subject to all of the rights and obligations of it.
Okay.
So that often comes in the reporting that you have to provide, and then certain scrutiny that can come for deals for some of the student athletes related to fair market value with certain third parties. That's an area that's still really being, I think, figured out by the NCAA and the defendant conferences, what that's all going to look like. But yes, it is. You have to opt in all or nothing.
Okay. So if I don't have $20 million a year, if I only have $5 million a year, I still have to opt in?
Yes, just because you opt in doesn't mean you have to provide that full benefit pool amount.
Okay, great. All right, so that's bucket number 1. What's bucket number 2?
Bucket number 2 is Title IX, is how is all of this going to work with Title IX? In that, if you're a school that is opting in or automatically opted in, then that's a universal question that every school has to face. And there is a significant amount of lack of clarity in there because we have not received any official guidance from the Department of Education or the Office of Civil Rights or any court yet. There's a number of there's a case out against the University of Oregon, the Schroeder case, that is not directly on point, but is a case that includes some allegations related to NIL within Title IX. So that may be instructive, but there's a lot of gray and a lot of uncertainty as to if and how Title IX could apply to NIL licensing payments, revenue share. One of the biggest areas that I think has been a struggle for schools is the roster limits. When within Title IX, one of the areas you have to be in compliance with is participation opportunities. And there's 3 ways you can do that. But one of those ways is to offer male and female student athlete opportunities that are proportional to your student body. And if you're changing your roster limits, your rosters, then you're obviously changing that proportion, and we'll need to reconfigure that. Or if you can't meet that prong of the analysis, then trying to meet a different prong.
Okay, so a sub question of that is, let's say I'm opting in. I don't have the full amount of money, but I do want to do roster limits. I have to be cognizant then of Title IX, because when I report to the EADA or wherever else I report, people are still going to be scrutinizing me whether I'm in or out of the settlement.
Yeah, so if you opt in, then you are subject to the roster limits. That doesn't mean you have to go most of the roster limits allow for adding more people more student athletes to the team. But even if you're not, you don't have to go out and add people. But there are some sports that carry rosters now that are much larger than the roster limit. So you may have to cut some athletes from those rosters. So if you're then, yes, you will have to turn around and then make your EADA report in the fall and have what the rosters are, what those amounts are, and that's publicly available. So with a few years of some data, we may be able to see the impact of these roster limits on both male and female sports.
Before we go to the third bucket, automatically it strikes me as being like deer in the headlights, looking at the ways they could be accused of treating athletes unequally with just these 2 amounts, the amount of revenue share and Title IX. So what kinds of questions are you getting as far as schools are? I know they're frustrated that the Department of Education is not giving them directions. So what kinds of answers do you have to help them through this? Because I would think those are 2 of the biggest buckets you've got.
Yep, and they're definitely related. The revenue share and the roster caps are related. But what we are talking about with schools regularly is if you don't know where you are right now, you need to figure that out. You need to make sure your numbers are up to date. Do you know what, for participation, do you know what prong you're meeting? What does your financial aid look like? And then how are you treating your student athletes? So those are the 3 big areas of compliance. And within the treatment, there's several factors and treatment areas that are looked at. But so know where you are right now so that you can plan for the future. Then there is, I think that schools need to be going through the exercise of what is our priority, and that could be very different across Division I. Obviously, some of the more well-resourced schools will be spending a lot more money, and may have some philosophical differences in how they're going to approach it. But everybody should be answering, what is our objective? What is our goal with the roster limits, with the revenue share, with NIL licensing payments? And then how can we mitigate some of the risks that are going to exist? You're never going to be able to fully solve them or get rid of them partly because we don't know exactly, how Title IX is going to apply to this or if it does apply to it. So it's really a kind of a risk-benefit analysis and what's our priority and how are we going to get there and where does Title IX fit into that? Because Title IX is not the only legal issue that you're going to have to encounter when you're doing that risk assessment.
Exactly. So let's go to the third bucket. What's the third bucket of questions you're getting?
Yeah, the third is schools that have said, yes, we want to take advantage of this benefit pool. We want to pay student athletes. How are we going to do that? Are we going to do it with a revenue share model? Are we going to do that through treating them as, we're licensing their name, image, likeness? Are we going to do both? And what does that contractual relationship look like? And what terms do we want in it? What terms do we not want in it? That's probably the third biggest bucket. And that's with the March 1st date coming up. And, one of the Q&As from the NCAA essentially said, you can be entering into these now so long as it's contingent on final approval and you're not making any payments prior to July 1st. So the men's basketball transfer portal opens in around the March time period. So that's schools that have decided we are going to make these payments. That's where a lot of that focus and attention is right now.
Okay, so I've two schools in the same conference. One decides that they want to put their focus and their energies on basketball. The other one decides they want to put their focus and energies on football. That's not a problem, right? The conference doesn't have to act unilaterally. Each school can make their own decision.
Correct. Yep.
Okay. Are you having any questions about the role of the conference in all of this, in terms of whether the conference leadership has decided any guidelines or parameters as to what they think they can afford as a whole versus individually?
We are getting some questions around, if our conference decides to have some of our own, we've made decisions as a conference that we want to impose. And we've seen some examples of that already. Is what are the risks of that? And that's really an antitrust question of if, because that's how all of this started with the House settlement, was these 3 antitrust lawsuits that said that the Power 5 institutions or the Power 5 conferences were limiting the market and creating anti-competitive restrictions. So the analysis that you have to do if you're going to decide that as a conference is, are there potential antitrust risks there too?
What's your take on that? I mean, conferences have anywhere from 8 to 18 members. Is that enough of a groundswell to be able to say, yeah, you're in violation of antitrust laws, or does it take multiple conferences deciding to do that?
It's a very lawyerly answer. It's really case by case because they are different. They have different geographic, footprints. You may have some conferences that are all in the Northeast, and then some that may be the Northeast to the West Coast. And so conferences may have a different approach for some of their sports. Maybe they're really strong in a non-traditional sport. So you really have to look at it case by case. But I do think the market share, though, is much different when you're talking about all of the Power 5 conferences,
right,
versus a single, mid-major conference. I think there's an argument there that single mid-major conference doesn't carry the same market power, market share, and so they are not restricting the market as
that
much.
makes total sense. That absolutely makes sense. Okay, any other buckets that you're seeing that people are concerned about?
I think the other bucket is just sort of operationalizing more the payments and how they're being paid, and that's a bit more granular, but as we're getting closer to these payments, that we're starting to get some more of those questions.
Operationalize. So are they looking to the NCAA or to another outside company that can make this seamless? I log in, I put my information, and then it goes to the right places. Are companies stepping up and doing that?
So the reporting functions are still, I think, really being developed, because some of the agreements will need to be reported, and it kind of, the most recent Q&A that the NCAA put out was talking about the different reporting that's required for different agreements, and it depends if it's between a student athlete and a third party, and if that third party is considered an associated entity or person, which is a new definition that was in the amended proposed settlement, if the amount is over $600. So I think a lot of that part of it is still being fully worked out. And then there is an analysis of between those, if there's a third party deal and that third party does trigger, like a collective does trigger the associated entity language, then it's subject to fair market value analysis. So who's doing that, making that determination, what that looks like. That will definitely be sort of the next phase of what's this all going to look like.
There's been a lot of discussion in the media recently about that fair market value. Who gets to determine it? How it's determined? Does it work differently in a large metropolitan area versus a small college town? Are you getting questions about that?
Yeah, and I mean, I think there's some, if you're thinking about a real estate transaction, if I'm selling my house, then, what somebody's willing to pay me for it and what I'm willing to accept is, I'm going to consider that fair market value. And it's, is it going to be that basic principle, or is it going to be much, much more detailed? My sense is it's probably not going to be quite as that basic example, but I think there is some, there is some thought out there that if there's an entity that's willing to pay a student athlete a certain amount and the student athlete finds that acceptable, then, how do we say that's not fair market value?
Right, right. Okay, you talked about associated individuals. Is that was the term you used?
Associated entities or individuals. Yep.
Okay. We don't call those boosters anymore, do we?
Yeah, that's basically what they are. The current phrase is that I think I can remember the acronym, but basically a representative of athletics interests is the current phrase that's used. But yeah, booster is what we're talking.
Okay. So in this settlement, if it's approved in the way it currently is, which we know things can change, will these monies that boosters, associated entities, give to the collectives then be part of revenue that comes into the institution? Obviously, they're nonprofit, and obviously, then there's Title IX implications. So, how does that work?
So I think for the most part, they're always going to be inextricably tied to universities for the most part, but I think they'll continue to operate as separate entities. I think there's sort of some question out there about whether they'll continue to exist. And I think that'll be a common question over the next 3 to 5 years. But for the schools that are going to be maxing out the benefit pool, 20 million, and as that increases over time, I think that collectives may come in and try to give on top of that. And that's where this fair market value analysis kicks in and says, you can do that, but it needs to be fair market value. The services they're providing need to be legitimate. It needs to be provided for a real purpose, it needs to be a real business deal.
Gotcha. So, but these are still, if they stay outside the university, then it's not tax deductible.
If the donations to it, correct.
Yeah.
There are still, despite some IRS guidance and rulings, there are still some nonprofit collectives, but we'll see how long those last and if they come subject to, audits or other scrutiny.
Yeah. One question that sort of strikes me, because you're hearing a lot about this term general manager. And this is somebody who's hired by the university to help the athletes navigate all this. What role or restrictions on their role might they have in this new world order?
Yeah, so I think these GMs are really, well, one, you're going to be, when you weren't paying student athletes, when you were just paying them a scholarship or cost of attendance or Alston payments, there wasn't really negotiation, at least above the board negotiation that was happening in terms of scholarships and a spot on the team. And now there may be at a lot of these schools. And so I think that you need somebody to help manage that so that your coaches are focusing on, recruiting the kids and the talent that they want, evaluating the talent, developing those relationships with the parents and the families and the support system that the prospects have. So I think the GM is going to both help with negotiating at the beginning what the amount looks like from the school, but then right now schools can be involved in finding deals or facilitating NIL deals for student athletes. So they may have a role in that too, which is kind of interesting because you're in the first role, you're not adverse, but you're on opposite sides of the table trying to arrive at a number. And in the second one, they're out there trying to get, more deals for you potentially or help facilitate those. It's an interesting, you'll have to wear several hats in that. And, we've seen it structured where it's across multiple sports or male and female sports. So that one, that's great for Title IX purposes, but two, it is going to present a lot of challenges for those folks to learn those sports and understand what endorsement opportunities look like.
I got to imagine that there's going to be at least a handful of athletes that are going to be approached by not so favorable advertising partners like liquor, like beer, like gambling, and other things. How are schools addressing that at this point?
Yeah, so I think in the, most schools still have some sort of NIL policy that might prohibit a student athlete from entering into those. Does that get opened up? I don't know, but I think in these NIL, in the revenue share agreements or whatever the contractual arrangement is with the student athlete, I think you'll still see some of those prohibitions. You still have to comply with our school policy, any school policy, but specifically this one too, and that those prohibitions will still apply. I mean, 5 years ago, 10 years ago, we didn't think we'd see student athletes in commercials. So, they may be in DraftKings in the next 5 to 10 years.
Yeah. I mean, that's what I think about it, is that kind of thing. I just saw, I don't know, was it Colorado or somebody, had their own IPA beer created just to be sold at the game. So why wouldn't an athlete create the same kind of thing?
Yeah, no, I think that's another good example. A lot of schools now have kind of their own beer of some local brewery. So, if you've got a really strong quarterback or center on the basketball team and that's going to sell, then that I think that's really conceivable that that'll happen.
Okay, on the last question on this topic, let me go really outside the box because I'm interested in this. Are you hearing about any NIL deals or concerns around the issue of investment in campus public-private partnerships?
Do you mean with?
Like residence halls, for example. You can be a shareholder. This is the deal. We'll be a shareholder in a residence hall.
I have not heard of that.
Okay.
And this is the first time I've actually heard of that as an idea, but so I'll probably be thinking about it for the next couple of days. But I mean, one of the questions, when you think about a revenue share is really sharing in the profits of
Right.
an entity. And when you share in the profits of an entity, you're usually some sort of owner or have some sort of equity stake in that. So it's kind of a similar, it's extrapolating that out further, but that's an interesting idea.
I think it's coming. That's why I asked, because I'm just trying to think what the next step might be and where the better value might be than just pitching pizza,
Yeah.
that type of thing.
Yeah, I mean, I do think along those lines, like schools will be able to utilize and pay the student athletes to be a brand ambassador for them. I mean, they already are and wearing the jersey and doing the appearances, but will they be able to do that even more? And you see what a lot, really successful athletes, professional athletes, how they, try to work with their former schools. And even from an apparel perspective, trying to, if they get an apparel deal at the next level and their former school didn't have that, trying to influence that. So I think you'll see those sort of things more in schools that are relying more on their current student athletes to promote them and to bring them good publicity now that they can pay them and ask them, more directly to do that.
Yeah, and they're getting their own shoes. I mean, it's just
Right.
it's a crazy new world that's out there. Okay, you do a lot of other things besides just focus on this one piece of, I won't call it legislation, this settlement. What are some of the issues you're hearing around NCAA infractions, compliance, waivers? Where are schools getting caught up in this area?
Yeah, the NCAA infractions area is, I think we're gonna, how this house settlement ends up, if it ends up being approved, there could be a new enforcement entity that handles compliance with that. So I think there's questions about what does infractions look like going forward, what rules are still exist that can be enforced, and there definitely are still plenty of rules on the rule books. There's still investigations happening, there's still cases being processed. So a lot of times, those are happening as they're supposed to behind the scenes, so you don't always know or hear that those are happening. But there continue to be cases. One of the areas that's most fraught for infractions is tampering, with NIL, with transfer portals, with no restrictions, at least on the number of times you can transfer. That's an area that is very, that coaches sometimes can't help themselves and trying to recruit before student athletes are in the portal. So that's an area. With student athlete waivers, getting additional years of eligibility, we just saw around the holidays with the
Yes.
decision on the junior college. So there's a lot of questions about if I have an athlete that played in junior college, what does that do for their
Right.
clock or their seasons of competition? So that, when we started doing a lot of the waiver work, a lot of it was around when you transferred and had to sit out a year in residence. And there were exceptions to that in a process where you could get that waived. And it's just as over the past few years, as student athlete movement has changed, kind of the different types of waivers that people have wanted help with have changed. We saw a lot of initial eligibility, schools or student athletes looking for help with initial eligibility waivers at the beginning of the year. So I think unless we get to a day where there's really few rules and restrictions around eligibility, I think that, some process like that will need to exist.
Yeah, I mean, we've gone such from one direction to the other. Back in the days when we had a clearinghouse and everybody had to hit a certain number of courses and numbers of years and grade point average. And now it just feels, I feel badly for the athletic academic advisors because I think they have some of the hardest jobs in navigating the transcripts that come in
Mm-hmm.
as athletes transfer from one institution to the next. And allegedly, supposedly, they're supposed to be on track to getting a degree. And that's not easy when you keep changing schools.
Yeah, it's not. I mean, it's always that's always conversations we have to have, and sometimes we're working with the school, sometimes we're working with the family and trying to explain to the student athlete or their parents or their support system that that just because you don't have to sit out a year in residence under sort of the old rule, you still have to be academically eligible, and you need to. That doesn't translate, one to one between schools, even schools in the same conference. Each school still has its own parameters and restrictions on academics, and that's so being able trying to do that. Trying to time that up with the transfer portal can be kind of tricky because shouldn't really be having those conversations before you're in the portal, but
Right.
sometimes the portal's at the end of, for some spring sports, is at the end of the academic year.
Do you or your team work with high school students and helping them navigate the transition to college?
So our practice or our firm has one of the biggest K through 12 practices in the state of Indiana. So we represent a lot of school districts throughout Indiana, and we have seen definitely an increase in the number of phone calls that we get from high school parents of like, what is this NIL? What can I do? How do I maintain eligibility? Indiana, as a state, the High School Association still does not allow high school athletes to get NIL, so they would lose their high school eligibility or they would be penalized under those rules. So we definitely get that, and then we also try to, through our colleagues in our K through 12 practice to help schools if they've got. I mean, we have like most states, we have some really powerhouse schools that can generate a lot of Division I athletes and just be a resource for them.
Yeah, Indiana has turned out an awful lot of really good athletes over the years, and I can't imagine that they aren't being approached, whether they're in eighth grade or 11th grade, that people aren't looking at the opportunity to jump on board with their potential financial future.
Yeah, and one of the things we've tried to do is, we're not certified agents. And we don't, that's not, we are there to provide legal counsel, but also just kind of explain, because we see so many aspects of college athletics, explain, the landscape of it, but then connect them, with agents that we know or have good relationships with, or that we feel comfortable referring people to. And then that way, then if they need legal counsel to review agreements in the future, they've got some protection there that's lined up. Because a lot of people think we're just agents, or that that we do the same thing as an agent does. We don't go out and procure deals for anybody.
Gotcha. Gotcha. Well, as we wrap up our conversation, what pieces of advice do you have for trustees and presidents about navigating this new world?
Yeah, I think there has to be really strong alignment, but like between athletics and campus and president, trustees, and CFOs. And so that's no different than other, big shifts in higher education. I think, there are presidents take a different approach at other schools. Some are more hands off on athletics and some are more invested in it and involved in more of the details. But I think that, we talked a little bit at the beginning that you need to know what your objective is. Once you have your arms around what is this settlement, you need to know what your objective is and what you want to do, and then have buy-in from all those stakeholders to do it. Because if this is approved and next year is the first year, it's supposed to go for 10 years, and the benefit amount pool has increases to it. So this isn't a one-time payment that schools may be making. These are decisions that are going to last for a while. So making sure there's alignment and everybody's on board and moving in the same direction and understands and appreciates the risks, I think is important. So there needs to be really strong relationships and communication that's happening.
Could not agree more. That's really important to have alignment and support and understanding that this is not going to be easy. There's going to be a lot of hiccups in the process. Kelleigh, thank you so much for spending some time with me and my listeners today. I think you've brought valuable insight into where we are right at this point in January of 2025. Thank you.
Yeah, thank you so much for having me. This was fun. I feel like I could talk about this topic all day.
I probably could too. Take care.
Thanks.